to consult before making these regulations. The only statutory duty is that in section 170 to 174 of the Social Security Administration Act. That was complied with in full. And I don't think my learned friend disputes that BAPIO applies, and one should not superimpose consultation duties over the statutory rulemaking procedure and the statutory provisions. I think that much is common ground. So if one's in the realm of rationality, that has to be considered against that background. Second preliminary point is based on how the claim was put below. The claim was put below on the basis that the irrationality challenge, the Secretary of State's decision not to consult, was irrational because it was based on a false premise or mistake about what her policy was. And if I just give the court a reference to this, supplementary bundle, page 115, one sees that at paragraphs 12 to 14 and 17 to 24. That is why there was so much evidence before this court about what the policy was. That was the basis of the challenge. The Secretary of State had never said, and we never say, we told you what the policy was in 2013 and we consulted on it. That has never been the Secretary of State's position. That evidence is only there to respond to the claim that the Secretary of State never in fact had this policy at all. And that's confirmed in the judgment. Paragraphs 12 and paragraph 19 confirm the case the Secretary of State had to meet as it was advanced before Mr. Justice Swift. And then the judge's conclusions at paragraph 19 to 22 that that case is met. Then one sees how the case is put in the grounds of appeal to this court. Core bundle, page 66. Ground 1. The respondent's decision to make the 2020 regulations without consultation was irrational because based on a false premise about the original policy intent when the regulations they amended were made. In other words, the Secretary of State didn't know what her policy was, the same as the argument being advanced below. And that formed the majority of my learned friend's case in his skeleton argument as well. That was the case that the Secretary of State was prepared to meet. Now it is said, and to be fair to my learned friend, I think there is one paragraph in the skeleton argument, paragraph 35, that the case is not that the Secretary of State didn't know what her own policy was, and so it was irrational on that basis. It's accepted that all the statements made in the contemporaneous documents that there was no consultation because she was reinstating her original policy intent is an accurate statement. That was her original policy intent. Now it is said to be irrational because when the Secretary of State consulted in 2013, consultees must have been taken to have understood that her policy was something different. So in other words, it's irrational because the Secretary of State did not consult on this policy in 2013. My first point is, well, the Secretary of State didn't consult. This was consultation by the SSAC. But the second point is common ground between us. There was no big red flashing light saying this is how the Secretary of State understands Regulation 14. But the point is that the Secretary of State said, not, I don't need to consult now because I've already consulted in 2013. That was never the Secretary of State's reasoning or rationale. The Secretary of State's position is, this is my settled policy. This is and always has been my policy. I don't need to consult on it. I'm just reinstating or amending the regulations to ensure that I can pursue my policy lawfully.
But also, she was going to consult in the way that she consulted in 2012, and if Mr. de la Mare was correct to say she should have realised she was not doing it on a correct legal basis, the people she would consult with would be the SAAC.
My lord can see where I'm going with
this.
Going
next.
That was my next point, my lord.
Right. Oh, right. So beg your pardon, I should be quiet here.
And the Secretary of State did exactly that. The Secretary of State complied with Section 172 and 173 of the Social Security Administration Act. That's why I took the time to take the court to those provisions and to show what was done in 2013. And that's how the consultation was carried out. So, my lord, essentially, my lady, my lord, we say it's completely unfair of Mr. de la Mare to characterise the conclusion of Mr. Justice Swift as a re-rationalisation of the Secretary of State's decision. It's nothing of the sort. It's exactly what the Secretary of State said. It's exactly what she did. She did comply with the statutory procedure, and importantly, there is no challenge to that. So now we're on to an argument. As I understood Mr. de la Mare's submissions this morning, it was that no Secretary of State could reasonably have taken that course. Well, I say, of course, a reasonable Secretary of State could have complied with the statutory procedure and did exactly what Parliament had required her to do. It's not irrational. Then it was said that the Secretary of State had failed to have regard to a mandatory relevant consideration. That mandatory relevant consideration being that she didn't consult in 2013. Well, first one has to find what makes that a mandatory consideration, because when one looks at the statutory provisions that actually govern what happened in 2013, there was no requirement to consult. And there's no statutory requirement to consult now. So how does that become a mandatory relevant consideration? It's not something that the Secretary of State was required to consider, because she complied with the statutory provisions that expressly govern consultation in this sphere. And then it was said, as I understand, that the public law error was that the Secretary of State had regard to an irrelevant consideration. And the irrelevant consideration was said to be that she was reinstating the original policy intent. And as I understood it, that was said to be irrelevant because the Secretary of State had not consulted on that in 2013. And again, the court has my point. She was not required to consult on it in 2013. But even if she had been, how could it be irrelevant to say, all I am doing is amending the regulations to make lawful what I have been doing for the last 4 or 5 years anyway?
Hold on a sec. Thanks, Alan. Sorry.
The live stream isn't working, but we're going to continue in any event.
I'm grateful.
Thank you.
At least mine was not the only technological disaster that occurred during the course of this hearing. And then, my lady, my final point on ground one, at page 211 of the supplementary bundle, is a list of regulations made effective in universal credit in roughly a 12-month period from March 2020.
Sorry, did you say page
211
11?
in the
211 of the supplementary. My lady, I hope this isn't too much of a jury point, but essentially the universal credit regulations are amended frequently and regularly. None of these measures, these amendment regulations, were the subject of consultation in 2013. None of them were the subject of public consultation when they were made in 2020, 2021. Is my learned friend's case that because Secretary of State didn't consult on these in 2013, she was somehow obliged to consult on all of these before they were made in 2020. That's the logical consequence of the submission.
Well, we assume that the first ones weren't unlawful. The problem with this one is that she got it wrong the first time round, and she told everybody this is the law, but if only she'd read it, she didn't realise what she was doing, nothing to do with it. That, I assume, is the difference, but I don't know, because oddly enough, I haven't read any of these 21 sets of regulations.
I had the word coronavirus.
But also, if you go back to 163 and paragraph 10.1, it's a bit of a non sequitur, isn't it? Why does it matter that the amendment restores the original policy intent as a reason for not consulting, unless the implicit inference is where we consulted on it in the first place?
Well, my lady, it matters because it's not new policy development.
But
if it were new policy development, the Secretary of State might think, well, it would be interesting to know what those, I hate the term stakeholders, but it's often used to cover those who are with an interest in the area, might have to say about this new policy development. But that's not what's happening here. What the Secretary of State is saying is it's not a new policy.
But you've accepted she didn't put it in red lights. It was not expressed on the face of the regulations. Indeed, it wasn't there, and it's been found that the policy that she adopted, original intent or not, was unlawful. It wasn't supported by those regulations.
Yes.
So it's a stronger point than simply not making new policy. It's something that wasn't there in the first place, on which she didn't consult, and I'm not suggesting that she had an obligation to, but she didn't. So why is it a reason for not consulting that she's restoring a policy intent that wasn't there in the legislation, whatever she subjectively believed?
Well, my lady, so again, going back to first principles, no duty to consult in 2013.
And no, I understand no duty, but why? I'm asking you, why is that an explanation? Why does it even make sense?
Well, the explanation is, I'm not making new policy, says the Secretary of State. This was always what I've wanted to do. This is what I have been doing. What is the point in consulting on it? It's not a change. It's not going to impact on anyone because this is what I have been doing over the last 4 or 5 years anyway. So I don't see, says the Secretary of State, any need to consult on it.
I mean, there is an impact legally because the world changes.
Yes.
But what she's saying is, I don't want any help, thank you very much, as to whether this is a good thing or a bad thing. It's what I've always wanted to do. I'm going to do it.
Yeah.
And I didn't have to consult before, and I ain't going to do it now.
I don't have to consult now.
Yeah.
My Lord, that's the point.
it. Whether it's lawful or not is another question.
I mean, my Lord, whether it was new policy development or not, the Secretary of State wasn't required to consult. But in this case, the point she's making is, I'm doing it very quickly, it's got to be done in 24 hours. I don't need to consult because I know exactly what it is I'm doing, and I've been doing it for the last 4 years. I don't need any help or assistance with that. So, my Lord, it's not an irrelevant consideration because it's relevant to the discretion that the Secretary of State was exercising. And she didn't fail to have regard to what was my learned friend says is a mandatory relevant consideration, to the fact that she didn't consult in 2013 because she wasn't required to consult in 2013. So rhetorically, what does it matter? So, lady, moving on then to ground 2. I think it's now common ground, the points in our skeleton argument, the 3 preliminary points about how rationality is interpreted and the threshold for review.
Yeah.
Very high in ordinary cases, it's even higher in social and economic policy cases, and it's even higher when it's a policy that's encapsulated in a statutory instrument. My learned friend doesn't depart from any of those. If the court needs a reference for any of that, my lady will recall Pantellerisco. It is the case I rely on. For the court's note, it's paragraphs 54 56 through to 59 and paragraph 90. My learned friend asked me to look at paragraph 89. I've looked at it very carefully and I don't see what relevance it has to anything, but if he can enlighten us, I'm sure it would be helpful for the court. So, my lady, that's the threshold, that's the agreed threshold that has to be applied. Now, again, the case below, and I don't want to keep taking pleading points, but it explains the nature of the evidence that this court has before it. The case below was that the regulations were irrational because they don't achieve the Secretary of State's objective, and all they do is impose extra and arbitrary hoops by forcing one through the workaround.
Yeah.
And it seemed my learned friend was not pursuing that in his submissions. And what he now says is that what makes it arbitrary is that or what makes it irrational is that the existence of the workaround per se is not irrational because the Secretary of State was entitled to move in small incremental steps, complex overlapping benefit regimes, etc., take the emergency step now and deal with the rest in a more considered fashion. But now he's saying what was irrational is that one couldn't backdate the universal credit claim once one had obtained the LCW determination through the workaround route. That's what I now understand to be at the centre of his case on rationality under Ground 2. And, my lady, there is no evidence specifically on that point because that was not the way the case was pleaded or argued below. But it comes back to the paragraph in Miss Garrett's witness statement that it wasn't administratively possible to keep the UC claim open while an LCW determination was achieved through whatever route it might have been achieved through.
Just pausing there. What I thought a few minutes ago, that the ESA was only ever a piece of paper telling you limited capacity for work and didn't have any backdating element to it. It was looking to the future. If in fact, of course, they'd been able to leave the UC credit unclosed, if the computer had a pause button, not just a no button, then the effect of the workaround would have been to enable the backdating to have occurred.
Yeah.
Just on that, the document you referred us to at page 312 of the supplemental bundle, CPAG reference to the workaround does have a section in it suggesting people say or ask the DWP to stockpile their claims.
Yeah.
Which I think is this point.
Yes, but my lady, that's right. And as I say, there's not detailed evidence on this because this was not how the case was pleaded or run below. But the point, the short response to it, assuming we are arguing this for the first time in this court, is that administratively or the IT capability to do that was not there. And that's what Miss Garrett says in paragraph 35B of her witness.
That really is unattractive, though, isn't it? You're acting unlawfully. You're leaving at least in place something that might temper the problem, and you're waiting to see how it pans out. But you're running a system that doesn't allow anyone to do it.
Well, my lord, it does allow someone to do it. And again, I think it's important to understand that this is an issue only about timing.
Yes, but that's what's important. The guy lost 2 years. If his mother hadn't kept going, he'd have lost all that money.
Well, my lord, the way that DWP dealt with this particular claimant's case was deeply unsatisfactory. The Secretary of State has acknowledged that, apologised for it and paid compensation for it. It is not the standard way in which the workaround claims were dealt with. That's my first point. But dealing with my lord's substantive point, the only difference is whether one applies for UC first, the claim is refused, one goes and gets the LCW determination through the workaround.
Just so everybody knows, the live stream is working. Sorry. Right. Sorry.
I've now completely lost my train of thought.
I have too.
The arbitrariness,
Yes.
the
Yes,
reason
we're on
why it's
time.
arbitrary.
Well, the timing issues. the solution, the emergency solution or the urgent solution that the Secretary of State put in place was to say that if you can get your LCW, it permits the workaround essentially,
Yes.
this is the thing that's criticised. So if you can get the LCW determination from the workaround and then come back and apply for UC again, you get UC.
Yeah.
We say, what's irrational about that?
Well, what's the point of a policy of a new regulation to bar new claimants from getting UC if they haven't already got their LCW, only to leave in place a workaround that is immensely complex to navigate around, and you've got to go uphill and down dale. What's the point of it? Why is it a rational approach to a problem?
Well, my lady, and that's why we have to take it in stages. So the Secretary of State wanted to make the UC regulations reflect her policy intent. But she didn't know what the consequences would be on the 3rd of August if she were to tinker or to change or to impact on the complex regime around contribution-based ESA and the contribution...
But it's been going, this workaround's been going on since 2017.
Well, my lady, yes.
So why doesn't she know?
But at that point, and we've got to look at the timing of the regulation.
Yeah.
What is it that the Secretary of State is doing? She knows the workaround exists. She's known the workaround has existed since 2017. I think that's common ground.
Yeah.
She was aware of that when she made the regulations. We've seen that in the ministerial submission. But the point is, one thing at a time. I'm having to deal with this urgently because we can't operate Regulation 14B as it then was lawfully. I can't do that because for the reasons Ms. Garrett has set out.
Yeah, I'm trying to work out in my own
But look,
mind.
can I just finish and then I'll deal with your Lordship's question if I may. We can't deal with it through that route. So the only option for the Secretary of State is, well, we have to change it to reflect our actual practice because that's the only way it can operate lawfully. There is this workaround there. The Secretary of State is told about it and knows about it. But it's almost does one dare to tread into another series of complex overlapping benefits regimes that can have other unintended consequences for each of those regimes on the next working day after the causa concession. And so we say it is rational to take the first step to make lawful what the Secretary of State's practice was and to keep under review how this workaround is working, to understand what the other potential consequences could be for other parts of this very complex overall social security regime, and then we'll deal with that as and when that information has been obtained and that review has been carried out, which is precisely what the Secretary of State did. And we say it's not irrational to take that staged approach because who knows what could have happened on a very urgent basis if the Secretary of State had tried to close off the workaround.
But that's what I'm trying to work out, you see, and have been for the last day and a half. I'm trying to put myself in the shoes of the Secretary of State on the 3rd of August 2020. And she's making these regulations. What is she doing? We know that she's stopping the direct universal credit claims for people who haven't got a pre-existing determination of limited capacity to work. That's fine. She knows that there's a possibility that an assessment showing limited capacity for work will be possible via the ESA route. I believe that knows that it's not going to make any monetary difference in terms of ESA because there's no money paid back for the ESA. So then the only question that the Secretary of State has got left to think about is, what's the relationship between getting the assessment under ESA and universal credit? And is it the case that she said to herself, well, there isn't any relationship because there wouldn't have been a universal credit application in place if the chap had gone for ESA? Or is she saying to herself, I'm lucky I've got a rubbish computer system and all the claims have been automatically closed because that'll deal with that problem. there wouldn't be any difficulty of an outstanding universal credit claim and a later LCW, which can be backdated for the universal credit claim, even though it'll have no value monetarily in the ESA claim. So was that what she was thinking?
Well, my lord,
Could there have been a possibility? I suppose the question is, could there have been a reason why somebody would make a universal credit claim and apply for ESA at the same time?
well, my lord, if one looks, so what the Secretary of State was doing in the summer of 2020, when she made the regulations, it was amending the regulations so that they say what they say on page 57 of the
Yeah.
Authorities Manual. So what she's doing is saying that I don't have to refer people under Part 5 of the Universal Credit Regulations to get a determination of...
No, exactly. So I've closed that route off
So I've
now.
closed that route.
But I know they might be getting the assessment under the ESA.
Yes, but then they get... Then, my lord, there's no requirement under Regulation 14 any longer to refer the individual for a work capability assessment to reach that determination. So, of course, any UC claim has to be closed because that is now lawful because there's no, unless there is a determination of LCW, there's no eligibility
It doesn't
for
have to be
universal credit.
closed. You're not going to pay it then. But closing it is
My
not...
lord, if one is not eligible for universal credit under the terms of this regulation, this amended regulation, which is now...
Because you had to already have your
to
determination.
already have your limited capability for work determination.
I understand
So
you
my
will
lord-
be able to get paid the universal credit because you still haven't got the LCW. But I don't see why you have to close it. Why you couldn't say,
My lord,
I
because one's
leave
not
it
eligible.
there.
Under the terms of the new lawful regulations, which make lawful the Secretary of State's practice of not referring people for an assessment under Part 5 of the UC regulations, the individual is not eligible for universal credit.
And does that mean your claim is closed if you're not eligible? There's a provision that makes that clear.
Well, my lady, they're not eligible. But it's
Yes,
whether it's
but the
closed,
point
refused,
is,
whatever,
if
rejected,
you
or
left
one-
the application on the table...
Why would you?
Because you've left open the ESA route, which may allow you to get the limited limited LCW thing, and if they do get it, they will then be able to backdate it if the UCA, the language of close means nothing. What they are saying is there is a refusal. I am bringing your claim to an end, so there's nothing left now to...
But there is something left, you're saying, because of
Potentially,
the ESA.
because she's left open the ESA route. That's what I'm trying to
But
figure out.
that's not a
Follow me?
positive part, as can be seen from the ministerial submission. That's the workaround route is not a positive part of the Secretary of State's policy. We know that. It's an unintended consequence of the way that other parts of the social security system work. She doesn't want to interfere with that in a rush within 24 hours of the concession in Causa. She doesn't know what the consequences of changing that might be. So what she says is, I'm going to amend the UC regulations to reflect my practice. So I no longer have to refer a UC claimant for an assessment under Part 5 to determine whether they have LCW. That means, unless at the point they apply for universal credit, it has been determined in the language of the regulations that the person has limited capability for work.
But it's in her
not
very
eligible.
regulation. It's in paragraph B1. The possibility of an assessment under the ESA. She's not disturbed that at all.
Yes.
So you say it's not part of her policy, and it's just an unintended part of another bit of the system.
Well,
But it's in there in the very regulations she's promulgated.
but Lily, it's not quite as straightforward as that. I'm sorry to add another layer of complexity. This is referring to the scenario where the individual had Part 4 and Part 5 of the ESA regulations, or where they've had the assessment under the ESA regulations and are eligible for ESA.
Oh, I see. Okay.
What we're talking about, they never get that far
okay.
under the
No, I
contribution-based
see.
ESA.
Say that again, I don't think I've got that.
Yeah, sorry.
That sounds terribly helpful in terms of understanding it.
Yeah, because Part 5 is where you go for the assessment
Yeah.
in the current regulations.
Whereas if if one is not eligible for contributions-based ESA because one has never paid the contributions,
Yeah.
the claim is rejected because one has never paid the contributions. One doesn't go on to determine whether one has LCW under the ESA regulations. I'm sorry to add this layer of complexity.
Yeah.
One only determines that in order to determine whether one is entitled to national
Credits.
insurance credits under the 1985 regulations.
Sorry, does that mean for practical purposes we should ignore that reference to the ESA regulations?
No, my lady, it deals with people who may have income-based ESA under the legacy regime. So before universal credit came in, you had ESA, you've had your limited capability for work determination, and you're moving over to universal credit. It deals with that. It also deals with people who are on ESA, so the existing claimants, and are moving into.
But for the workaround, for the purposes of the workaround, that's not the right bit of this regulation to look at. Is that?
That's right, my lady.
But I still haven't got it.
Yeah, I think we need to have it. Can you say it at dictation?
Yeah.
Yes. I will try and repeat it, yes. Let me find my...
I think we're going to get the whole copy of the ESA regulations. I think the extracts that have been supplied probably aren't helpful. We probably need the whole of Part 4 and Part 5, because my understanding has always been that even the assessment that's conducted for the purposes of national insurance contributions is nevertheless an LCW assessment under Part 4 or Part 5.
That's my problem. That's my
That's
problem.
my
And the thing
understanding
is, I don't accept this phrase, closed. You are eligible to be paid if you meet certain conditions.
Yes.
And one of the conditions is that you're not receiving full-time education. Then there is an exception. But as part of the exceptions, you will still get it if you've got the determination.
My lord, we're all agreed on
Yeah.
that.
Yeah.
And I can't see why it's not relevant to leave the universal credit application open in the sense of not completely determined, because whilst you are not currently clearly eligible because you haven't got an LCW under the relevant universal credit thing, but nonetheless, you could still apply for an ESA and at some stage in the process, for whatever purposes, getting insurance credits or a sum of money, you will get the LCW. And if you get the LCW and you haven't closed, as you've put it, the universal credit application, it'll be backdated.
Well, my lord, can we look, please, at Regulation 14,
Yeah.
Yeah.
57 of the Authority?
We have to start at Section 1 of the Act, but we go to 14, yeah.
I don't want to go right back to that,
Yeah.
my lord, but it's the wording of what the Secretary of State did. The person is entitled to disability benefit, and it has been determined that the person has limited capability for work, but one has to go down underneath the Roman numerals, and that determination was made on or before the date of claim to universal credit. So, my lord, the criteria for eligibility are that determination was made on or before the date of claim. So one can't say, because you might get a determination 6 months later, you'll be eligible. You won't be eligible under the amendment that the Secretary of State has made, because the determination has to have been made on or before the date of claim to universal credit, where the person's receiving education on the date the claim is made, or if you start receiving education and then you claim a different date. But that's...
But then I don't understand how the
one is
workaround
not
works.
eligible. Because the claim is rejected because you don't at that point meet the criteria for eligibility. The workaround works
Go slowly.
because
Claim rejected because at that date.
one doesn't have the LCW determination made on or before the date of claim to UC.
So not eligible.
Not eligible. The workaround works because the Secretary of State will then say, here's these other benefits you could apply for. Someone goes and
Let's do it by dates. If we put dates in, it's easier to understand. 1st of January
2018.
2018. You make
Hang on, we're looking at the revised.
No, the revised. 1st of January 2021. Okay? 1st of January 2021,
Yes.
you apply.
You apply, my lord, Yes.
Somebody looks at it on the 1st of February 2021.
Doesn't matter when they look at it, my lord. The key question is, do you have
At that date.
determination on or
At that
before
date.
the 1st of January, which is the date of your claim to universal credit?
So let's assume you don't. You're not eligible.
You're not eligible.
So
the
what
claim
happens?
is rejected.
What happens? So that happens on, let's say, the 1st of Feb. Rejected.
The claimant can then say, I will go and get my LCW determination by another route, the workaround route, by applying for contributions-based ESA. He gets the LCW determination. He then comes back to UC.
So he
let's
gets
say 1
his,
April.
so the 1st of April he says, oh gosh, I can go and get the same piece of paper by applying for an ESA. So he applies on the 1st of April 2022 for an ESA, and in the course of that being dealt with, he gets his LCW.
So let's say 1 May. He
1
gets
May.
his LCW.
And then he rushes back to the computer and they'll say, too late, we closed it on the 1st of February 2022.
But my lord, then he makes a fresh claim.
And he makes a fresh claim from then,
on
yes.
The first, on the 2nd of May, he says, Secretary of State, here's my claim for universal credit, and here is my LCW determination that I achieved through a different route, but I have that LCW determination on or before the date of the claim to universal credit.
And he's only going for the ESA LCW because in the past, if the law had worked properly and once you saw Badu, you should have been referring him anyway. Rather than closing his UC claim, you should have been referring him for his
So
his
the
But there
assessment.
was then, so my lord, and if I could ask your lordship please to read the statement of reasons attached to the consent order in causa to see the basis upon which the Secretary of State accepted
Well, where is
the
that?
claim was unlawful. I am just going to find that, my lady. It is at page 169
Of the core,
of the supplementary.
the supplemental.
Joe, you said he had, I just had a look.
Right.
So regulations 14 through to 33. So all
So there never would have been an application for an ESA generating
No, she'd
an
have to
LCW
refer
once a
him for an
universal,
assessment.
yes, once a universal
Yeah.
credit claim.
Yes.
Yeah.
So
that's
which
the point.
paragraph do you want us to look at in the
My
agreement
lady, it's
statement?
paragraphs 9 through to 12.
Matters justified.
The main bit is 12. It's the failure to refer the claimants for a work capability assessment under Part 5 to determine whether they had the limited
Yeah.
capability to work that breached Regulation
Yeah.
14B.
Yeah.
So one couldn't determine, under the old version, the original version, one couldn't determine the claim for universal credit without having referred for an
Yeah.
assessment.
Yeah.
Yes.
What the 2020 regulations do is change the timing of all of that.
Well, they closed down that route, but they left in place the other route that you could go via ESA.
And make a new claim. They
Yes.
don't say you keep it
Yes.
the original claim.
No, no,
open.
no.
Yes. Milady, I think that was the point my Lord Justice Lewis was
I
quizzing
see how it
on.
works now, actually.
Yes.
I
So-
do see how it works,
And
yes.
my Lord, that the point is that the ideal final solution? No, of course it wasn't. But the Secretary of State, the next working day after this is acknowledged in causa, decides I've got to do something on an emergency basis because I can't operate the original 14B lawfully. I've got to change that, but I don't know what's going to happen if I also try and change the workaround or close down the workaround or change the way in which one can get an LCW determination under the ESA Act. Because who knows, it's a bit like a Jenga situation. If you pull that bit out, who knows what happens to everything else that is built on top of it.
I think the problem is, and I don't sound disrespectful, though it's going to sound disrespectful, it's, with a very great respect, the loose language of UC application being closed. It's irrelevant what the piece of paper has
Well,
got
yes,
stamped on the
it's
top.
It's rejected.
It doesn't
It's
matter.
not eligible for what you say.
It could be hanging in the universe, but the LCW would never have come before that.
I'm not sure I follow,
Oh.
Lord. I'm sure I'm being very slow.
I understand.
My lady said, last I'm on the same planet as someone in this courtroom. There is progress. But the point is, it's not the UC application,
It's that it has to be made before.
being open or closed. It's that you can't, whether it's open, closed, or whatever it is,
hanging.
you can't do anything about it because you don't qualify, because the LCDW has got to have a date stamp that predates the date stamp on the computer.
I mean, look, that's the point I was making about those words.
But it's nothing to do with it's closed.
Yes. One is not eligible. One is not eligible for university.
One will never become
unless
eligible.
your
You can
LCW
wait until the cows
predates
come
the
home.
claim.
Yes.
Yeah.
You'll never, not you are not eligible, you will never become eligible.
Unless you get your LCW
Before.
determination.
And
then make your use
Yeah.
of
Yes. And, my lord,
Thank goodness somebody understands me.
but I think we've got to how it works. My lord, my response to this ground claim, it's a very simple one. It's the one that was accepted by the judge, that something urgent had to be done on the 3rd of August.
Is it relevant that that's all of her own making?
Well, my lady, how one got there is, in my submission, neither here nor there when one's looking at this. Indeed, I say that on the PSCD as well.
Yeah.
I hate to invoke the phrase, but we are where we are. As at the 31st of July 2020, why she got there doesn't matter. That was the position the Secretary of State was faced with.
But the conscious exercise that she went through on the 3rd of August 2020 was to say, I'm closing the UC route. I'm not going to have an obligation to refer people for an assessment for UC purposes. I know you can still get an ESA, but because of the way I'm determining the phrase eligibility, that LCW will never actually help somebody claim universal credit. They'll still have to put in...
It
No,
will.
my lord,
It
yes,
will.
But only later.
It will.
Well,
but
only if they
later.
make a fresh claim, I was
Yes.
about to say. Only
Yeah.
if you
Yes.
put a new one in.
Yeah.
Had I finished the sentence, yes. You've got to...
I do apologise.
You've got to make a fresh claim. The fact
Yeah.
it went on your
He's
computer
getting
in
a
January...
taste of his own medicine.
Yes, it's January, yes, exactly. It's January, I'm
Leadership should say
excited
that,
because
I
I've
probably
agreed with you, it's so rare. But you've got to put in a new, fresh document with a new date on it, or you've got to go on your computer and put a new date on it.
Yes. I mean, one says why, and one standing back from it, one can say, well, of course, the obvious thing to do is what you did in 2021. And yes, if one had time to consider it, and one had time to be aware of the consequences
Yeah.
of what happens if you poke that bit of the social security system, what happens to everything else?
I mean, some may say it's a little rich,
Yeah.
suggesting you needed time when you had since.
Yes.
There it is. There it is. We've gone round that.
Melanie, of course I accept that.
But you say
the
you are where you
question
were
for
on the
this
3rd of
court-
August and you didn't do anything to make things worse. You left the possibility of getting an LCW available, but you still had the time limit, which meant that they couldn't get UC credit, yes.
Yes. And the question is it irrational for the Secretary of State to say, I'm going to go this far and no further the next working day. I am going to keep under review how these different bits of the system interact together. And I'll then decide what to do about this workaround issue once I've had time to look at how it's all working together under this new legal regime. And that is what paragraph 14 of the ministerial submission is saying to the minister. We are aware that this workaround works. We will keep the operation of the policy under review with a view to attempting to establish to what extent this might be the case and to what extent it can be used, and determine whether this remains appropriate. So, my lord, we say that's not an irrational approach. And the only reason, as I said, my learned friend now says it's irrational, is because, well, you could keep the workaround, but only if you backdate it.
I don't think that's fair. I think what he said is it's a very funny way to achieve your objective, to leave a workaround in place that is far more complicated and has these arbitrary results because there's no backdating. But to close the obvious, it's closing the motorway, but leaving the road that goes all around the houses and finally gets to the same destination.
And letting the Secretary of State decide the speed at which you're going to be driving.
On which subject, forgive me for rising, I've been given instructions. I said earlier that my client had been compensated for the delay in relation to his claim. It was over a year, the benefit he lost. He's been offered the sum total of £75 in compensation for that delay. And that is a perfect illustration. Your claim is mucked around or mishandled for whatever reason. It delays the point of your eligibility under the new regime.
Yeah.
You've lost a year of benefit because of the delay in his
And
claim.
got £75 to show for it.
And my lady, as I've said, that's not the way in which that part of the claim was dealt with is not the way it should have been dealt with. It's not as a result of the regulations. It's because of maladministration in the way the claim was handled.
Any chance she's going to give him the rest now then?
My lord, I'll have to take instructions on that. I'm not sure I was ever aware of the amount of compensation, or if I was, I'd forgotten about it. But my lord, coming back to the point, the point is, and we say it is a very simple one, was it irrational? We're applying the very high standard that the court has to apply to say, I'm going to go this far and make what I'm currently doing not unlawful, or make it lawful, and then I will work out, once I've kept the workaround under review, what I'm going to do about that workaround. We say it is not irrational for the Secretary of State to go that far to deal with the emergency or the urgent problem and come back to deal with the rest of it when she was fully aware of what the rest of it was.
I mean, it might have been different if there hadn't been a finding that it was unlawful, because what she did is respond to the unlawful part of the route, the motorway that was unsafe she closed, but she left the road that was windy and went through the thickets because nobody had said that was unlawful, and waited to see.
And she will come back to see how to deal with that in due course, which is exactly what she did. My lady, on that basis, we say that's not irrational. That was the reasoning adopted. We haven't actually looked at what the judge says on that, but I'm not going to read it to you. But I know the court will have read it, but that is essentially what Mr. Justice Smith said.
Okay.
So, my lady, moving then on to ground 3. This is the contention that it is irrational to... Well, it's an irrational and discriminatory distinction that is drawn in the 2020 regulation, because the existing claimants remain eligible, the new claimants go round the winding road, shall I put it that way. Now, again, I hate to start every submission on the ground, but how this case was put below. This was argued below on the Article 14 ground.
We've got that.
Mr. Justice Swift found that it was not, it was just, if there was any distinction, any difference in treatment, it was justified under Article 14. And it was specifically said by the claimant below that if the claim fails under the Human Rights Act and under Article 14, he cannot possibly succeed under rationality. Now, no challenge has been brought to the Article 14 conclusion, and yet here we are having an argument about rationality. Well, on the claimant's own case below, that's not an argument that's open to him.
Well, the point is that the differential treatment between the two groups was justified for 14 purposes. So you say, how therefore, if it was enough to get through Article 14, would it not be enough to... And I can't remember, did you show us Section 42? I might have been resting my eyes. 42, party make regulations in this part may be exercised to make different provision for different cases or purposes. Yes. You did show us that.
That's why I put it in the bundle, my lord. You might be 2 steps ahead of me, as always. But yes, there is that power. Of course, I do accept the power has to be exercised rationally, but in the context of the very high standard of review, both because it's social security benefits and because it's statutory instrument. And my lord, we say these are the very kind of distinctions that the Secretary of State for Pensions is entitled to draw. And, my lord, the rationale for it is the rationale that I've shown the court in paragraph 23 of Miss Garrett's witness statement, which evidence was accepted by the judge. And essentially, the response is the two cohorts relied on by my learned friend are in fundamentally different positions. One cohort is already dependent on benefits and may not go into, or would be deterred from going into university if they were to lose those benefits. And the other cohort has never had them. Now, both of their needs, we say, can be met by the student finance system because that's what it's there But the aim and the policy rationale, as explained by Ms. Barrett, is not to discourage those who already have the benefits from going into university by the fact that they would lose them if they were to go into university. And we say that that simply is a fundamentally they're in a fundamentally different situation from those in what Malone Friend calls the new claims category.
What about the other alleged irrationality? There's perverse incentive. What should happen up and down the land of England now is everyone should reach 18, take a year out, stay at home, claim LCW, and then go to university.
Well, my lord, first we say, well, where is the evidence of the perverse incentive? Because those...
In the place of the regulations.
Well, my lord, we say the student finance system is there to support and meet the subsistence needs of all students. The additional costs arising out of a disability are met by the additional elements that the non-disabled students do not get. And so where is the perverse incentive?
Oh, I see.
So that's the first response.
Well, the maintenance ones alone, you have to pay it back, don't you? Don't you keep the universal credit?
Well, my lord, yes, but every other student finances their studies through maintenance loans, not through state benefits.
But all the people who are disabled can say, let's wait a year.
I'm sorry, my lord?
All these students can say, let's wait a year, I'll go up, I'll take a year out, I'll stay at home, I'll read lots of stuff ready for university, and I'll get my LCW. And and you say, well, that's just life, and that's what the Secretary of State's chosen to do. And if something goes wrong with that, and there are too many people taking a year out before they go up and claiming universal credit, she'll have to address that as and when it arises if it becomes a problem.
Well, my lord, precisely. But the point is, at the stage of the 2020 regulations, there is still the workaround. It took, as I have accepted, it took far too long in this claimant's case, but it does not take that long in the vast majority of cases.
Well, where's the evidence of that?
Well, my lord, there was never any evidence to put it the other way that we needed to respond to. The point is, things went badly wrong in this case, as we've accepted that from the outset, including the application form was lost, then it wasn't processed, then it had to ask him to go and submit it again. That is not a standard run-of-the-mill event. I hear sniggers behind me, but it is not a standard run-of-the-mill event upon which one can assume that is how the Secretary of State automatically deals with claims of this nature.
Claims brought by people who've already faced a lot and are trying to do the best. You change the regulations, then you treat them like that. Really, it's a bit disappointing, isn't it?
But, my lord, of course it is, and the Secretary of State has apologised for that from the outset. It is most unfortunate that it happened in that way, and as I said, the Secretary of State has apologised for it. I'll investigate what compensation was paid. I don't know the answer to that question. So, my lord, of course I take on board that point. It did not work well in this particular case, but one doesn't make policy based on maladministration in one particular case. What we are looking at here is the Secretary of State entitled to draw the distinction that the Secretary of State drew? There may be some perverse incentives, we don't know. If that becomes obvious, then that would, of course, be looked at. But, my lord, what we're dealing with is a situation where every other student does have their needs met through the student finance system. A particular exemption is made for those who are already dependent on state benefits, and those who were not are in a fundamentally different position.
Yes, I understand that. It's just that Mr. Delamere's point is that for a very small cohort of people, the LCW people, they could actually wait, and that's the perverse incentive for them, because if they do that for a year, they'll not get a maintenance loan with a big bill at the end. They'll get universal credit.
You will get a maintenance loan with a big bill at the end. You're expected to take out maintenance. You're still required to take
You're still going to have to do that, even with universal
The
credit.
amount
You
of
can't avoid that then.
The amount of maintenance you take out is then used to reduce the amount of universal credit you receive.
You can't avoid it, you won't get a benefit.
No.
But the whole point is
Right,
that the
okay.
system recognises that the living costs of people with disability are greater. That's the whole reason why there are additional payments paid for those who have LCW or those who have LCWRA. And those payments cumulatively take you to a place where what you receive is considerably greater than what you receive under the maintenance system. The LCWRA increments are £340 a month. That's £4,500 the scenarios that are modelled don't even include that. So the delta in a case like Mr. Casey's case is nearer £10,000.
My lord, the way that the universal credits work is that they deem a student to have taken out a maintenance loan, even if they haven't actually taken
No, so
it out.
they only get the amount less the maintenance loan,
Yes.
they'll still end up with the debt then.
With the deduction, my lord,
Yeah.
that's right. With all the other deductions that we've that I've already outlined.
Yeah.
But my lord, in terms of the perverse incentives that my lord was putting to me, particularly when one's looking at the 2020 regulations, there are a number of responses to that, as we set out in the skeleton argument. It's essentially either one uses the workaround, which should not take as long as it did in the claimant's case, or there is a period at the end of the school year in June, before one starts university in October, when the disregard doesn't apply at all. And my lord, there's simply no evidence here that this is having the perverse incentive that my learned friend says it does. And it's a question, this is precisely a question of judgment for the Secretary of State, who's tasked with safeguarding public funds through the benefit system, to make a call, and it is a judgment call, a policy call, as to where that line is to be drawn. This is not a system where individuals are left with no subsistence support at all. There is a bespoke system that is in place put in place by the Secretary of State for Education for funding those who are students in higher education. Part of that includes additional funding that they may receive as a result of their disabilities. Now, those who are in the existing claimants category are unlikely to be facing the sort of financial hardship criteria that others might face that would entitle them to get the discretionary benefits or the hardship funds from the university. So one has to put all of those things in the round when one is trying to compare an individual in one situation with another individual in a different situation. But these are very difficult lines, very difficult judgment calls to make. And those are, we say, for the Secretary of State. There is a rational reason for the distinction. That is the one advanced by Ms Garrett, and that is what makes this lawful.
Mr. Delamere said there's the same deterrent effect on both groups. The same logic applies to both groups. It's just one group has got the concrete money in his or her hands and the other doesn't, but the same
in the broad sense of one might not go to university at that time, but the deterrent effect is different of you have this money in your hand and you will lose it, and you may not get this money that you've never had. It is a different kind of deterrent. It is a different kind of factor that operates on an individual's decision making.
Okay.
So, my lady, turning then to ground 4, we all know what section 149 says. We're all familiar with the principles about how in the case law about how duties to be applied. There are 3 points that I would like to draw from those cases. I'm not going to turn them out, but simply give the court the references. As we said, we've all agreed on bracking, but what is also not in dispute is what the Court of Appeal says in Bailey and Brent, which is at tab 19 of the Authorities Bundle, page 323, and it is the heading, it's in the head note there, that one should not speculate on or investigate or explore the possibility that a proposal may impact on protected groups, nor can they be expected to apply, indeed they are to be discouraged from applying, the degree of forensic analysis for the purposes of an EIA that a QC might deploy in court. The basic principle, I don't think that's in dispute. The second point that I make is that where the very nature of the exercise directs the mind of the decision maker to the needs of a protected group, then the substantive requirements of the PSED are met if the decision maker considers those issues properly. So if what you're thinking about is the disabled, then if you're dealing with that particular issue, then you don't have to cite it, you don't have to go into the same level of detail, because the decision is all about those relevant matters in the first place. And that, my lady, is the MacDonald and Kensington and Chelsea case, tab 20, page 341, and the paragraphs are, it's the judgment of Lord Brown at paragraphs 23 and 24, page 354. My lady, paragraph 24. Whereas here the person concerned is disabled and the public authority is discharging its functions under statute which expressly direct their attention to the needs of disabled persons, it may be entirely superfluous to cite and to infer from the action, etc. And then the third point I make is that the due regard is the regard that is appropriate in all the circumstances. Again, I don't think it's controversial, but if the court needs authority for that, it's Baker, tab 15, paragraph 31. And we say all the circumstances includes the need to act urgently in light of the concession in Causa. Now, of course, I've heard the points that my lady in particular put to my learned friend about self-induced urgency. I accept that that's obviously a factor that one has to consider, but one can't get away from the state of affairs as they existed on the 31st of July 2020. And the consequences of what would have occurred if the Secretary of State could not have made those regulations on the next day because she had to embark on what my learned friend says is an open-ended consultation exercise with, I'm not quite sure how many people, whether it's all students across the UK, all disabled students, or, well, England, not the UK, but all disabled students or anything of that nature. If the PSED has the result of saying the Secretary of State cannot make urgent decisions, we say that would be a startling consequence. When the courts say it's due regard as a regard that's appropriate in all circumstances, it must take into account the speed at which the public authority is required to act. So we say when the court is considering what due regard is, one does have to think about the time in which the Secretary of State had in order to make these regulations and the nature and extent of the analysis that could reasonably be carried out within that time frame. In terms then of what the PSED requires, the fundamental point we make is that it is due regard in the exercise of the public authority's functions. So the next question the court asks is, what is the function that is being exercised here? And the function that's being exercised here is making the 2020 regulations to make the Secretary of State's existing and long-standing practice lawful in circumstances where she needed to take urgent steps to preserve the status quo. So when one is looking at the impact of exercising that function and taking that decision, one has to bear in mind that there is no substantive change on the ground. I take, of course, what my Lord Justice Lewis is about to say, that, of course, the legal regime was changing. Of course, I accept that. But on the ground, the impact for those students being affected by these 2020 regulations is minimal, because all it is doing is making lawful that which the Secretary of State had been doing in any event. My Lord Justice Lewis put to my learned friend yesterday, I think my learned friend came up with a number of lists of things that the Secretary of State should have been told, and I think at last count I got to 8 of those things. But he accepted in exchanges with my Lord Justice Lewis that 2 of those points were the most important. The first was how many disabled students are affected by the 2020 regulations, and the second was how much are they going to lose. Now, my Lord, in terms of how many, the obvious answer is none, because the Secretary of State has been operating this policy for a number of years anyway. Nothing's going to change.
No, but I think the question is, given that she can't do it any longer because she's been very naughty and been acting illegally, how many will be affected, given that they will now have that which Parliament and the law said they could have. So you can't dodge it. You're doing exactly what they did, but in reverse. The question is, how many people now who should have something and should always have had something no longer get it?
Well,
because you've changed their legal entitlement.
yes, but my lord, the starting point is the practice.
No,
I
the
take
starting point is the law. We live in a country based on law, or at least we do here, yes.
I tell you what my lord says, but that is practically on the ground impact.
No.
In terms then of...
But you
how
said
many-
the function is making regulations, making law, not dealing with practice.
Yes,
We're
my lord,
looking at
I
the
accept
law.
that.
Right.
Of course I accept.
And the law was going to change.
Yes.
Right.
But then one says, how many students are affected by that? So how many students are worse off after the
It is the number of
2020
students who
regulations
qualified
than
under
there
the
were
law before and will not qualify under the law afterwards. The
But
fact
my
that she's been acting reprehensibly and illegally is regrettable, but it doesn't alter the test when you're working out the impact. The impact is Regulation A said they could get it, Regulation B says they won't get it, and we need to know how many people are in the different groups.
But my lord, the point I'm coming to is that is impossible to know.
Ah, that's a different point, yes.
Yeah, but that's the point I'm trying to get
Yes.
to. my
Well,
lord.
you said a moment ago nobody was affected,
Yes.
but now you're saying it's impossible to know.
Yes, that's
So
different.
that's-
My primary submission is one that the court does not like,
No, we
which
don't
is that
like
it's a
it.
change in practice.
Yeah.
So I'm now moving to my
Right.
second position, which is that it is impossible to know. And it was certainly impossible to know in the 24 hours that was available between the Kaiser concession and the date when the 2020 regulations were made. How can one know?
Well, if you tie your hand behind your back, it's impossible.
Melody, I was literally doing that. So that wasn't a conscious action. Well, but my lady, they weren't applying under the old regime because it was very well publicised that they weren't going to get it. So how, rhetorically, how is one going to know? Certainly
We just
within-
can't know how many people were put off. We don't know how effective your illegal actions over many years has been in stopping people getting what they were always entitled to.
My lord, I might phrase it slightly differently,
Oh,
but
sorry.
in substance, that is
That's
that
it,
is the
really.
point. Yes. Because I think my lady friend referred to it as the suppressed class.
Yeah.
Well, how is one going to identify the suppressed class?
Well, that's the problem. We know that Mrs. Badu and Mr. Kays and Mr. Cowser have persevered. So we know at least 3 people should have got it, and eventually they did get it by different means. But because you've been lucky with your illegal subterfuge, we don't know how many other people might have got it.
Yeah, my lord, there was a question raised by Mr. Justice Swift below about how many people applied and were refused. So I should show the court that.
Yeah.
That is at page 306.
So, and that could be found by interrogating the UC system, could it?
My lady, perhaps if we could start this at 305.
Yeah.
To see what which can show the court what the Secretary of State held and what he didn't.
Right.
Does my lady have that?
Yeah.
Yes. So 305, DWP does not hold statistics showing the number of disabled students who are paid UC in accordance with the Secretary of State's policy, i.e. the existing group. This is because the benefit claimant will already have been in receipt of UC or a legacy benefit at the point of moving into education. They don't submit a new claim, so the statistics aren't held. Then paragraph 5, DWP does hold statistics for new claims that are made by disabled students who are not currently in receipt of UC or legacy benefits. The most recent data was obtained in June 2020, and between 2015 and June 2020 there have been 398 new claims. So that was the number who did pursue an application.
They're in the same category as Mr. Keith's case.
But the point is that isn't the relevant group.
That's not the suppressed group.
Yeah, so roughly,
Exactly.
you know 100 people
So
in there, roughly.
I'm simply showing the court that to show what
Yeah.
DWP did hold. But it's not the group who would have applied had all the documents online or had all the welfare groups advising them or all the student support schemes told them that this was a route they could have gone down. And that is not a statistic that the
So why doesn't the Secretary of State hold statistics for people who apply and are told, no, you're not eligible, and they close the claim?
Well, that is the statistic in paragraph 5. That's the 398.
Not that you're saying it doesn't cover the people who were put off
who never
entirely.
applied in the first.
Oh, I see. Okay, so those are the new claims that were closed or went on to ESA.
Yeah.
Yes.
Yeah. Oh, I see.
Sorry, my lady,
Yes.
I'm not sure. Those are the people who applied for universal credit.
Yes.
The claim was rejected. They were not referred for a work capability assessment.
But they may have pursued ESA assessments.
Yes, the Secretary of State doesn't hold
Yeah.
statistics about that either.
Yeah.
So, but what my learned friend says is you can only discharge comply with Section 149 if you know the number of people who were deterred from applying for universal credit because of the operation of the unlawful policy. And we say that's not a figure that, one, DWP doesn't hold statistics on it. Two, it's not a statistic that DWP is capable of holding because it requires one to assess who would have done something that they never actually did. And three, it's certainly not information that DWP could have somehow found out within the 24 hours before the 2020 regulations needed to be made. So that's what we say about that ground. The second piece of information that my learned friend says was essential was the how much are they going to lose category. And I hope I've already shown the court this. It's, again, there are a whole wide range of possible permutations of that. It's not they will lose £5,000. So what will be achieved by going through that exercise? We say nothing, it's an unknown element. What the Secretary of State does know is what is set out in the Equality Impact Assessment, and if the court will indulge me just for a few moments to look at what that actually says. And it says, but I think the point my Lady Justice Falk put to my learned friend, it's, well, these are all obvious consequences, aren't they? And we agree with that entirely, my lady. What is it that the Secretary of State needed to know? It's that there are these two cohorts. One group will keep universal credit, the other group will not. What are the consequences for that group? And we say that was made obvious to the Secretary of State through the equality analysis. And if I can invite the court to turn to that, please, that's page 147. And we see the brief outline of the policy starts towards the bottom of page 148. So it's explaining what the department's policy was in that first paragraph. What the policy has been and who will or will not be referred. It's then saying that policy has been subject to challenge and the UC regulations are being amended to support the policy intent, namely that the disabled student with a qualifying benefit must already have been determined to have LCW. So what then is under the evidence and analysis section? It's the background about what is available to students under the student finance regime. So the Secretary of State knows what one is going to get if one doesn't get universal credit. Then the second paragraph under that heading, the DWP is assess the equality impacts of the proposed amendment. The DWP is satisfied that while some people with a disability will remain excluded from entitlement to UC, if they're already in education before claiming UC and do not have a determination of LCW at the date of claim. So that's the group who are going to be excluded. Secretary of State knows the impact on that group because he's told what student finance is available to them. Then it says that's considered to be justified. The maintaining of the existing policy benefits, so who benefits from this policy? It's those who've already been determined to have LCW in giving them extra support by way of allowing them to enter education. So that's the advantage group, and it's also been told who the advantage group are and what the consequences will be. Then the next paragraph, the amendment will mean that existing UC claimants who move into education before being determined to have LCW may lose entitlement, and then explains what can be done to mitigate about that. And then we have the consideration expressly under the protected characteristics. Now, on age, we say, except, of course, there's less analysis under age than there is under disability, but the consequences are the same, as Mr. Justice Swift noticed. The real issue is not an age issue, it's a disability issue. And in terms of age, you'll recall that that DWP officials in the exchanges with SSAC explained what the issue was. The vast majority of students, obviously, are younger rather than older. It's an obvious point. And then under disability heading, the first point, it only impacts on disabled UC claimants. Then we say those who've been determined to have LCW will retain entitlement to UC. So again, it's identifying the advantage group. Claimants without it, claimants with it but who do not have the finding will lose entitlement when they go into education. They can then claim UC will not be eligible unless they meet one of the other exceptions. Again, it's confirming the different groups and the impact on them. And it's stating in the paragraphs then, the following sentences, it's explaining that some people with a disability will not be entitled to universal credit, so the Secretary of State is fully aware of that. And explaining why, because the student support system is in place to meet their needs. So exceptions are generally made where students have additional needs that are not met through the student support system, and disabled students do not represent such an exception because they can access fees and living cost support for their higher education courses through the student support system. Again, it's making clear to the Secretary of State what's going to happen to those who don't get universal credit. It's not precise numbers, of course I accept that, but the court has my point that it's impossible to get exact numbers. It's the big picture point. Then it says the application's policy is limited to a disabled person with PIP who's already been determined to have LCW, as it's intended as extra available support to such a claimant to give them better prospects of moving into work, given that they're already in the benefit system. So that's, again, identifying for the Secretary of State the policy rationale that underlies the decisions that are being taken. Others are able to make decisions about becoming a student in the light of the student funding available to them, or will continue to be a student on the basis of the student funding they've already secured. So, my lady, we say that is more than sufficient to discharge the duty under Section 149 in the circumstances that arose in this particular case. That is a conclusion with which the judge agreed. And in terms of, I don't know whether it would assist to go through the criticisms that the judge considered and rejected, because those are not now the criticisms that are made of the EIA before this court. But nevertheless, the judge did carefully consider how the impact on those with protected characteristics of disability and age were treated in the EIA, and we say he was not wrong in the changes, in the conclusions that he reached. There's also a commitment at the end of the EIA to monitoring the impact of its policies, and will use evidence from a number of sources on the experiences and outcomes of protected groups, and they will monitor the impact of the policy in due course. My Lord, there's the point my learned friend looked at about how do you get the information and how you're going to evaluate it, but it's not particularly pertinent to this claim. There was no further data available. The use of this data is yet to be evaluated, as is the need for consideration as to the robustness of its use in future equality analysis. So, my Lord, my lady, we say that was sufficient to discharge the PSCD. And in terms of the 2 points that my learned friend now relies on, I've explained why that is not reasonable information that DWP could have. In terms of the Tameside point, that where my learned friend essentially says Tameside is included or encompassed within the PSCD and the duty to investigate.
There is a reasonable inquiries.
Exactly, my lady, it's a reasonable inquiries, but that is a judgment, like everything else, for the Secretary of State. That can only be challenged if the Secretary of State's acted in a way that was unreasonable or perverse. And if authority is needed for that, it is in the SG case, tab 23 of the bundle, paragraph 313. I'm not sure how any judgment gets up to paragraph 313, but that is the reference at page 512.
And that's SG.
We say one has to, it's not SG in the Supreme Court, it's another SG. Okay. But we say one has to look at what information the Secretary of State needed to gather in light of the circumstances that applied in this case given the need to take the urgent action and the impact in practice.
Have I missed it? Just thinking about the future, does the Secretary of State, has she said now she realises looking back, she shouldn't just have left Badoon as it was? Once it was drawn to her attention that there was a problem with the law, it's probably a good idea to address it. Or is that not something we've looked at and not something I should worry about?
I'm sure the Secretary of State would have been given advice on that point, my lord.
Well, just so we wouldn't want it happening again. I mean, unlikely, I suppose.
My lord, yes. If I can just turn my back for a moment.
Just I have to give a judgment on precisely this point where they all try yes.
My lady, unless I can assist further, those are our submissions.
Thank you, Miss Clement. That's very clear.
Can I
Yes.
start where my learned friend started?
Yes.
She took you on a tour through the ESA provisions to establish the proposition that nothing in the ESA provisions has changed. That's of course right. All that's changed between the 2013 regulations and the 2020 regulations is the use that may be made of an ESA generated through those provisions. Under the 2013 regulation, it matters not when you get such a determination. If you've got it already when you made the claim, Bob's your uncle. If you get it after you've made the claim, it's as good as a determination under Part 5 of the Universal Credit Regulations. That status is changed by the new text of the new Regulation 14.1b because it requires you to have that piece of paper in your hand before you make a claim. And that's what takes you immediately into the arbitrary function, which is this: how much of the period of your education you can claim universal credit for is a function of how quickly you can get an ESA LCW assessment that then entitles you to make a claim. That's the basic arbitrariness, and that's the basic arbitrariness that underpins the grounds 2 argument. So that's the ESA regime. The second point my learned friend sought to establish by reference to her supplementary materials was that the scheme of entitlements under universal credit is intended to marry up with what you can get in terms of student finance, such that in effect student finance wasn't intended to replicate what you might get through a combination of work, and there was intended to be no duplication. What that analysis misses with respect is the very reason why there is a gateway into the receipt of universal credit for certain categories of people who are in full-time education in the first place. And the reason is that the categories of people who can passport over are likely to be the very people who will attract the enhancements that takes one beyond the standard allowances. If you go back to the last table in the Regulation 36 of the standard allowances and look at the various sums herein set out.
Where is that?
It's page 33 of tab 4 of my learned friend's supplementary bundle.
Yeah.
You have the standard allowance here, which is for living amounts.
Yeah.
And there's a parallel table which we haven't been given, but exists in relation to Regulation 26 for housing costs.
Yeah.
This is for non-housing costs. And I readily accept that if you take the amount for housing costs, the standard allowance for that, and you put it together with the amount here, that's what we're talking about. The problem is that there are certain categories of case where the need for enhancements are recognised. In relation to children, that's why there's a Regulation 1C exception and D exception for childcare. Then, in relation to disability, LCW, that in itself entitles you to an enhancement, and that explains why the condition is what it is. The whole policy is, these are categories of case where we recognise that something more than the standard amount, which is replicated by the student allowance, is required. Then you get to LCWRA, and you've heard me bang on about this point. £341.92 paid per assessment period, that's about £4,100 a year. That is to meet the additional subsistence costs, the daily living inconveniences of living with the sorts of severe disability that get you into LCWRA. Now you'll immediately remember that the scenarios at page 208 of the bundle, the scenarios simply model the position for somebody with LCW.
Yeah.
Yeah.
And you'll also remember in those scenarios that those who hadn't left home, who had previously been in receipt of universal credit, would lose universal credit. They'd lose their entitlement. That was scenario 2, I think it was, in the supplementary bundle. If you go back to the supplementary bundle 208, if you look at scenario 2 and compare it to scenario 5, somebody who was under 25, who was living at home, and therefore wouldn't be getting a housing element, they would lose all entitlement, because once the double calculation provisions, or the double recovery provisions...
Yeah.
Sorry, which
5 and 2.
5 and 2?
5 and 2. That's the relevant calculation. It was only if you were getting the higher rate of UC payable to those over 25 that you would be left with something, £771 a year. Compare and contrast the position of somebody who is living away from home, and that's where the position bites. And all of these models don't even take into account LCWRA.
Just remind me, when Mr. Case had his assessment, did he actually qualify for limited work capability?
Yes, that was what I showed you very first thing this morning that I'd forgotten to show you yesterday.
Right, well, I've forgotten all about it. I mean, that was
I showed you the decision that showed that
both,
Yeah.
accepts.
LCWRA.
So, now, I readily accept, of course, that these are merely indicative numbers. My learned friend made a great play about, well, you might work in the chip shop, and therefore you're going to get some additional income, and therefore the actual amount you're going to receive is going to be adjusted by how much you work. Of course. No part of my case to say otherwise. But nevertheless, what you've got to do to discharge your your PSED is you've got at least to do some kind of order of magnitude investigation to understand what sorts of sums would be at stake. And that's exactly what the SSAC asked to happen. That's exactly what these scenarios do. They show that even for somebody with simple LCW, the order of magnitude impact is £4,500 to £5,500. The fact that you can supplement your income through work is another point that's entirely neutral, because we're all accepting and accepted that people with LCW, or indeed people with LCWRA, can and do still work, just as my client has attempted to do so. So the fact that the numbers might be smaller is true either side of the delta with respect. So again, another wash. When you add in the LCWRA factor, you're talking about a minimum case for someone living away from home of £4,500 of the delta, and a maximum case, once you take into account LCWRA, and I think Mr. Royston will correct me if I'm wrong, I think LCWRA is a fixed amount and not adjusted, it's the amount shown in the table, you're talking about a maximum impact of nearly £10,000. Yeah. So, yes, these calculations are rough and ready, but surely what the law requires you to do is some form of ranging calculation that tells you the orders of magnitude of the types of loss of income that might be at play before the person, whether an existing claimant or not, might obtain work. So those scenarios are precisely the sorts of materials that should have been before the Secretary of State and considered by the Secretary of State, and my learned friend can hardly contend that they're impossible to generate, given that they were very rapidly produced pursuant to the 23rd of September request from SSAC. Then there was a point made vis-à-vis the general presumption, well, you're expected to apply for bursaries, etc. And Mr. Case hasn't told us what he's done. Completely irrelevant. We're dealing with a challenge to the regulations based upon the impact on the disabled and the two different cohorts. We're not dealing with a challenge to the regulations based upon the particular factual circumstances of my client. He's obviously illustrative of the problem.
Well, to be perfectly honest,
right?
what you're challenging, if you go, is the decision
Absolutely.
in his individual case. And one would, to be honest, have expected the claimant, in a case like that, to have put all the information forward. I would have expected it, to be honest, at first instance.
Well, I don't. The honest answer is I don't know why that evidence is before the court. But in any event, it's not, in my submission, still relevant to the legality of the regulation.
No, I understand that, but this is a different point.
No, I understand my lord's point, and it's fairly made. As for the point about, well, this is designed to secure non-duplication, the policy is one of non-duplication, that is obviously true as the justification for the basic exemption from entitlement to universal credit for those in full-time education. That is the philosophy that underpins the situation if your or my daughter goes off to university, and that's the reason why they don't receive support. But it is not the philosophy that underpins any of the exemptions. And the very reason why the regulations contain measures specifically to calculate and adjust for the receipt of income in relation to maintenance is a recognition of that fact. It's a necessary recognition that those who are exceptionally entitled to a universal credit, notwithstanding the fact they're going to further education, need to receive more, and therefore that the income that they receive from maintenance should be taken into account. And that's true across all of the cohorts. Regulation 14A, B, 1A, 1B, 1C, 1D, 1E, 1F. Same calculations for all of them. Is to work out what more that they need. And if there wasn't more that was needed by reference to their circumstances, disability in the case of existing claimants, there wouldn't be any deterrent effect by reference to the removal of universal credit. Then we come to the point made by reference to point M in the SSAC submissions.
Yep.
And my learned friend said this, and it's an important point, she said. She said, young students won't be in the existing claimant cohort. Young students will be in the affected cohort. In other words, the new claimant cohort. And we say, precisely. Existing students are more likely to be predominantly older, mature students. And that's why the impact of this policy is not just upon disabled people or a cohort of disabled people, it is on young disabled people. And it's that combined factor that calls for the impact by reference to age also to be taken into account, which it was not.
But the point is that although they're young disabled, their youth is not in fact the thing that generates any problem. I know they didn't say anything about that, but what generates their problem is their additional needs because of the disability rather than their relative youth.
Well, it's still material. The disadvantageous effect is being concentrated on young people, and it's particularly material.
But not because they're young.
Well, it is because they're young. It's not intended because they're young, but that's how it will operate in effect.
I spoke loosely, but it's not the youth that generates the need, but it is the young who suffer with those, the young with those needs who will suffer, yes.
The detrimental effect will be concentrated in the young.
Yeah.
And that's not without significance under the scheme of universal credit, because, of course, the amount of universal credit received by the young is already lower. So we say that that is a relevant factor, and when we come to the ground for arguments, it hasn't been addressed. Now let's come to the grounds. And one of the things I would invite you to note is this. What became increasingly apparent in my learned friend's submissions was the central role played in the inability to operate the old system lawfully because of the way that the computer was designed. That was the source of all of the urgency in the situation. You heard my learned friend give substantial evidence from the bar, which I'm sure is true, about the inability to change this hugely complex computer system overnight to make it possible to keep cases open and to deal with the complexities of assessment. I'm sure all of that is completely true. and it's said to be true in Miss Garrett's witness statement. But if it's true, does it not inform all the grounds of challenge? Because if that is the case, how could the Secretary of State have ever contemplated a consultation which kept the policy open if there was no possibility of compliance with the law in the interim? That was not just the source of the urgency, that was surely the source of the decision not to consult. And if it was, what the Secretary of State is really saying is my past illegality and my past construction of an immutable and rigid system, computer system, that can only operate in this way, means that I've got no choice but to implement this immediately, and consultation is off the table. It's yet a further form of self-induced frustration. As to ground one, we've been around the houses. I agree fully with the point that my Lady Justice Simler put to my learned friend. The question really is as simple as this. Why is paragraph 10 of the explanatory memorandum formulated in the way that it is? What is the relevance of the fact that you are restoring the original legislative intent? What does that even mean as a reason? It just doesn't seem to have any rational connection to anything at all. If the real reason is I couldn't operate the system in any other way, then say as much. It's nothing to do with the fact that the original intent was X. It's the real reason is that I built a computer system that could only operate in the way that I thought the law was. And that being so, I have no choice but to move the law to match up with my computer system so that I can continue to process claims lawfully now that I've conceded that it's unlawful. And with respect, that is not a proper reason to refuse to consult. It may explain why the regulations are introduced at breakneck speed to provide legality in the interim. It may explain the speed with which the Secretary of State acts, but it doesn't explain why one passes beyond mere transitional provision to deal with the immediate short term whilst you consider what to do in response to the situation. It certainly doesn't amount to a rational reason as stated, and it certainly doesn't amount to, my learned friend's evidence is correct, a complete statement of the reasons. Then we come on to ground 2. The first point to note here is, contrary to what my learned friend said, it was not, in fact, impossible in the circumstances prevailing before the 2020 regulations to have your claim considered under Part 5 of the Universal Credit Regulations. Paragraph 29 of Miss Garrett's witness statement, the reference for which is supplementary bundle page 121, recognised that there were a number of cases in which people persuaded decision makers to send their case off to assessment, as Judge Poynter had indicated was the correct approach. The Secretary of State didn't like that, so what happened was that each time a decision maker did that, and it was identified by the Secretary of State, the Secretary of State sent them the unlawful guidance, saying don't do this again. That was the evidence Miss Garrett gave. So it's certainly not the case that it was impossible. We don't demur from the fact that it wasn't the ordinary response, but certainly the law was being complied with by some decision makers. Then my learned friend affects not to understand the point I was making by reference to Pantella Risky. So let me show you the passage in question in the authority bundle. Now I'm having the computer says no moment. The karmic wheel has gone full circle.
It's tab 34 in the authority.
You have to take that on trust, my lady.
Doesn't help him.
You've got
My thing is frozen. Please.
Your tiny tablet is frozen to adapt.
Oh, I know, my
from Little
lord.
Britain.
Really enjoying this.
Tom.
You could try this.
Being offered a
You're
further
being offered
tablet.
another one behind you.
Thank you very much, Tom.
And if Miss Clement was a gentle lady, she'd offer you her. Oh, you have got a bundle, have you? You have. Oh, you did. Right.
You very much do. I'm very grateful. In the finest traditions of the bar, but my junior has got there with his tablet, so no doubt this will bites me in the
So we know
backside
we've got an
short.
overdose, I suppose, of tablets, yes.
Page 820
Yeah.
So the paragraph my learned friend places particular emphasis on is the particular, there's a further point at 90, this is a highly complex scheme. This is the passage cited in response to her argument here. But what's absolutely apparent from this case is that turned on the particular facts identified at 89. And the facts show that although the DWP certainly appreciated that where a claimant was paid on a cycle rather than the calendar month, that receipts would vary from month to month, here's the critical part. The impact of that variation on the threshold for the disapplication of the benefit cap in the cases of present kind was only really focused on as a result of CPAG's post-implementation representations. That means that the Secretary of State is not able to point to a considered policy decision made at the time that there was no workable way of avoiding the payoff cycle without unacceptably compromising the objects of the scheme. In other words, it was an unintended, unforeseen consequence.
It was.
It was an unknown, to use the Rumsfeldian cliche, whereas here we're dealing with a known and knowable known. Namely, how the workaround operated. It is as different a case as one can imagine. And the Secretary of State went into this position, went into this amendment, eyes wide open, to two things. That this exemption existed, and that the effect of the legal change made to the 2013 regulations by the 2020 regulations would be to modify the practical operation of the workaround. Why does it modify it? Because now the critical thing is whether or not you have the ESA determination in your hand at the time of application, rather than whether or not you've managed to get it after the event in the face of a department refusing to put you through a Part 5 assessment unlawfully in breach of their duties to do so. And it's that in your hand requirement that then generates the arbitrariness, because how much benefit you'll get is a function of how quickly they will conduct the ESA investigation. And I jumped up very rudely and I told you that my client had lost a year of benefit and received £75 of compensation. That is a perfect illustration of the known and knowable effect of these changes. So my learned friend's next tag is to say, oh, well, this is just a one-off case. We can't, you know, it's very unfortunate. We've apologised profusely to Mr. Case, but most of the time we're brilliant. And that's the basis on which you should proceed. Well, the sad reality is there are two further case studies that were put in evidence by Miss Cadd, to which the Secretary of State responded, and they both equally illustrated the extent of the delays in question. The responsive evidence is at paragraphs 24 to 27 of Miss Garrett's second witness statement, page 220 to 222. And you'll see in relation to the two case studies, the full details of which haven't made their way into the supplementary bundle, you'll see that the first case study, the individual suffered a delay from application for the ESA credits from the 15th of March 21 to the 21st of September 21, so over 6 months of delay, for what should be, in relation to somebody who's already in receipt of one of the three benefits in question, a relatively mechanistic assessment, frankly. There's no particular difficulty necessary in each and every case. Case study 2, there's a delay from the 30th of March 21 to the 11th of October 21. So we're looking at a pattern of delays of over 6 months in relation to these claims happening with some regularity. Now, that is a perfect illustration of the arbitrariness of the system that now says you have to go through this jungle, this network of various effects, in order to get this piece of paper, and then once you've got this piece of paper, you can make the claim. And the fact that you've lost the benefits and can't subsist without eating into your PIP in the interim is not our problem. Now, as I understand it, the main answer to that is, well, you take the system as we found it, we had to do the best we can, and we didn't want to tweak the system to make unintended consequences. What are the unintended consequences that are capable of arising for ESA when the ESA regime on my learned friend's own case hasn't been changed. There aren't any. All that has changed is the universal credit system. So there can't be any unintended consequences outside the universal credit system. That is nonsense. And what it really comes down to is the argument my lord put to me, which is, well, you're just doing the best you can, and aren't you better off having a system where you have to go through this nonsense thicket than having nothing at all? And I thought about that over lunch, and my answer is this. Just imagine this scenario. Imagine the Secretary of State said to you, and it's an absurd example, imagine the Secretary of State said, in order to get your universal credit, you have to do the hokey-cokey first. You have to do something absurd and ridiculous, and when you do it, you get your benefits. So, because I want the benefit, I do that absurd and ridiculous thing. Is it any answer to the irrationality or the objectionality of the scheme in those circumstances that if you don't do the absurd thing I ask you to do, you won't get the benefit, and because you've got the benefit, the scheme must be defensible? Of course it's not. Of course, it is not a defence. The scheme as a whole is absurd, it's irrational, it's arbitrary, and it should be struck down. And it may be that the consequences of that and the doing of justice is achieved through relief. And here, it would be achieved through the relief of striking down the measure and restoring the old regime. In other cases, relief may be done by declaring the scheme to be irrational, but leaving intact the benefits that have been achieved through doing the hokey-cokey, because that's the best justice of the system. But it is no answer to the central charge that the scheme as a whole is irrational in those circumstances by imposing...
That's changing your claim again, because you didn't challenge the scheme as a whole. It's the regulations upon which the decision was based. And the reality is the hokey-cokey option had been there, but had never been used.
No. No, that's not true with respect. The hokey-cokey option, the real hokey-cokeyness of it is introduced by the backdating element. That's the problem. The scheme always said, perfectly sensibly, in the original conception, you can get your LCW by any number of routes because it's the same test. And that's why Regulation 40, not just Regulation 14, Regulation 40 says you can prove LCW either under this scheme or under Part 4 and Part 5 of the ESA. That's a perfectly sensible scheme. It's coherent. When it becomes the hokey-cokey is when you say you've got to do all of that, however long it takes before, and then you can make the claim. So it is tied up with the instrument as adopted. And I should point out in that connection, I checked all of the provisions my learned friend referred you to from the ESA. They're all from Part 4 and 5. So my original assertion is completely correct. The sorts of assessment you will go through in order to get NIC credits under the ESA regime are under Part 4 and 5, and are therefore the provisions referred to in paragraph 14b(1) of the relevant rules. So that's ground 2. Ground 3, the concession made below is pretty obvious. It's about intensity of review. What was being said is if you don't win under the justification test of Article 14, if you get there, you're not going to win under Wednesbury, because Wednesbury is not a more intense standard of scrutiny than the Convention. And the concession we've made here is we don't wish to put our case under the Convention, we just wish to put it under Wednesbury and get straight to that standard of justification. And we say you get there by Cruz and Johnson and Matadine and Pointu. And it was notable, my learned friend's case to argue that the basic inquiry required by Cruz and Johnson and Matadine doesn't arise in this case. This is unequal provision being made for different classes of case that appear the same. So the argument on intensity of review doesn't really take one anywhere. The real nub of it is the argument that the two cohorts are in fundamentally different positions. Yeah. That's the nub of it. Yeah. And there's two questions that arise in relation to that. Question 1, is that in fact true? Does the fact that you've got the benefit in your hands, such that the fact that you might lose it, alter the nature of your need? Because that's the real question at the end of the day.
Or does it put you in a materially different position for the purposes of a decision to not take away existing
Yes.
benefit, but to close off the
Yes.
avenue for
But
those who
the second question that arises is, even if there is some difference in the position, does it justify the extent and the nature of the difference of treatment? Now, as to the first point, we don't accept that the dependence, the prior dependence or receipt of benefits, alters matters one jot.
But who decides that, and what are we doing? Isn't that really what the Secretary of State has got to say? She's going to make some exceptions from the basic provision that you can't get UC if you're receiving education. She says, I've got one group of people who've actually built their lives around the fact that they're getting so much money per month, and they've taken decisions and committed themselves on that basis. I've got another group that haven't launched themselves into post-schooling education yet. I'm going to treat them differently. Is it for her to say those two are different?
Well, obviously, you should be paying her views on that front great and careful respect. But her views are not conclusive. If your view is, in fact, it's a distinction without a difference, particularly when you understand the Secretary of State's own objectives, reasons, and purposes, and the scheme of the regulation, then in a case such as that, and I accept it will be a comparatively rare one, you must say it.
But what are we saying? Are we saying we disagree with you and we would have done it differently? Or are we saying what you have done, because we don't actually think much of your justification, is irrational?
It's irrational to treat those categories of case as being sufficiently different to warrant the extent of the differential treatment that they've received. And the reason you can say that...
So hold on, irrational to treat
those
cases as so different
as to warrant any, still less the amount of the differential treatment that they've received. And the reason is...
Hold on a moment, sorry. Irrational to, I'm going to write slowly. I don't have a laptop. Irrational to treat those cases as so different as to warrant the difference and certainly the extent of the differential treatment.
Yes. And the answer to it actually lies in this table of allowances. Because it's this table of allowances and the equivalent table in Regulation 26 that's identifying the generic needs of people in various different categories as accepted by the Secretary of State. And once you accept, as you have to, that maintenance doesn't meet those basic needs for people entitled to the various enhancements set out in the two regulations, you have to ask yourself, what is the material difference between the position of people in the new claimants and the existing claimants cohort in terms of their needs? And there is none. It's just that one has the comfort of continuing to receive money and the other is told to go out with the begging bowl for the various discretionary sources of funding to meet a delta of up to £10,000. And it comes down to, we don't want to pay. Actually, it comes down to resources are scant and scarce, and that's never, ever a good argument for discrimination. It may be an argument as to the level of provision or how people in the relevant same circumstances may justify paying everyone a bit less. It doesn't justify paying one person in the same position X amount and another person in an identical situation 0. That's just not rational. And that's the basic problem here. There isn't actually a distinction between the cohorts other than the adventitious fact of when they've made their claim. It is an adventitious fact, which is why it generates perverse incentives. And my learned friend, with respect, didn't have any real answer to the points put to her by my lord on that point. The perverse effects are just as obvious as all of the matters canvassed in the EIA by reference to how things will obviously operate. And if you were told as a student that if you wait 18 months before you go to university or 2 years and get your benefits in hand, you'll then be getting £10,000 more that you won't have to borrow or find from your family who may be in straitened circumstances, etc. Many people will take that choice. That's obvious. So when it comes down to it in relation to ground 3, there is no answer to the basic charge. These are individuals in the same circumstances with the same needs receiving irrationally different treatment.
How are we doing for time? It's now 4:45 and we...
3 minutes on the PSAD. I really won't be any longer than that. I'm sorry, my lady. There have been a lot of questions.
Not during your reply, to be fair.
That's probably fair. There's been a few. What was striking, lastly, in relation to the PSED is this. When you put my learned friend's submissions together and ask yourself, what is left of the duty in the case where the Secretary of State has left herself with no choice but to legislate in a day or act unlawfully, it's that there's nothing left of the duty on her submissions. She says the fact that the situation of urgency is self-induced is irrelevant, find things as it is, and that being so, there was really no choice but to act in the way in question with the imperfect information available. Now, that can't be right. It's not reconcilable with those passages I showed you in bracking that show what happened before, during and after irrelevant. And if it were right, it would be simplicity itself to reduce this obligation to nothing in many circumstances by simply creating a situation of urgency and then saying, that's the best I can do. And my learned friend had no answer as to the question as to why nothing had happened in the intervening 4 or 5 years in which the policy had operated. Her only real answer, once we got beyond the, well, we should concentrate on what the changes in practice, which Fox was repeatedly shot, all we got to was, well, it's impossible for us to find out. And that is not right. You can do the ranging calculations that show the orders of magnitude in typical cases. That happened for the SSAC, and even those scenarios don't embrace LCWRA, as I've said already. But then as to the numbers, we know, because it happened after the event, you can model or find out the number of claims that are refused. We know, because Mr. Butler did it, that you can do another order of magnitude calculation about suppressed demand. That was the calculation he set out in his witness statement at paragraph 14 of his first witness statement, that compared how many people had accessed ESA with how many people were now accessing universal credit. And he looked at the difference in the numbers and said it was 10,000 beforehand and 5,000 now, so it looks like the suppressed demand is 5,000. There is no evidence in response to that. It's never been suggested that that's an unsafe exercise. Obviously, it's not an exact exercise, but once again, it's an order of magnitude calculation, which I referred to in opening, and my learned friend never answered that. So it's not impossible to get a grip on the basic size of the problem. All of that could and should have been done for the Secretary of State's benefit. And equally, as my lady said, why aren't the relevant details being logged as the policy is implemented? Why aren't you tracking changes to universal credit when people go into education? You must know if they have LCW or LCWRA, and you must be able to work out whether or not there's been a recalculation under Regulation 69 and following, because it's a very particular and singular calculation. The data has never been looked for. And if the data is not looked for, and if it's not held, and it's not been held for the intervening 5 years, that's another cohort of self-induced frustration. Because the evidence isn't, we couldn't begin to log it. It's just that we don't have it now, because we've never thought it necessary to hold it. Lastly, as to age adding nothing, and this really is the last step, you have my point. Those impacted are young disabled. The fact that they have both characteristics affects the depth of investigation and the quality of material or evidence required under the bracket test before the Secretary of State can be satisfied that he or she has had due regard to the problem in hand. And as you know, wrongly it was concluded that there was no relevant age factor in the case. Unless I can assist you further, thank you incredibly for your extra 5 minutes of patience.
Thank you. Thank you both to counsel who addressed us, and also to those sitting behind. I know an enormous amount of work goes into preparing these cases, and we're very grateful to all of you for the work that you've put in and the clarity of your submissions. We will be reserving our judgments, unsurprisingly. They will be circulated in the usual way for typographical error corrections, not further submissions. And can I remind you of the recent flurry of cases about the confidentiality and the contempt provisions in relation to those drafts. We hope that you will be able to agree any consequential orders and that there will be no need for any further attendance, but that we can address in due course. So thank you all.
Courts rise.